No matter the shots that were taken, we don't pretend they weren't there. I would call the leadership every single time and say, hey, so that grenade that was just thrown at us, I know you threw it.
The ownership attorney has entered the chat. The Weavers built Uncle Nearest into one of the fastest growing whiskey brands in America. A lot of people are covering the facts of this case and the most recent updates as of July 28th, 2026. And some are doing an amazing job. So go check them out and catch up. I won't repeat all of that here, but I will explain what this case teaches you as a business owner. Here are 3 lessons from this case that actually matter legally for entrepreneurs wanting to protect their business. Number 1, I trusted my chief financial officer. I trusted my CFO. It's only a defense if your trust was reasonable. And reasonable means verified. Every inventory report a company sends its lender is a legal promise that the numbers are true. The law calls it representation, and the company is bound by it no matter which employee typed it up. Fawn Weaver testified that she never knew the barrel numbers were inflated. Although the law does allow her, like I just stated, as CEO, to rely on her officers, the courts will ask whether that reliance was reasonable. A CEO who never orders an independent count, never questioned figures that unlock millions in new credit, and has no system checking the numbers for taxes or otherwise, may not be deemed to be relying on an appointed officer. Rather, the court may be looking at that action as looking away. And courts treat looking away as a choice. If your name is on the company, the promises your people make are your promises. Build a second set of eyes into every number that leaves your company. Lesson number 2. 3 pieces of fine print are at the core of this entire case. Number 1, collateral. Once you pledge an asset, it is legally spoken for, and selling it to pay somebody else is like selling a car or a home that the bank holds the title to without telling them. That action can accelerate full payment on a loan. Second, covenants. When you sign a loan, you are not just promising to pay it back. There are specific covenants in that agreement which can trigger a default separate from any missed payment. You can make the payments, but default on other requirements for the business, such as a requirement to maintain a financial threshold, which was the situation in this case. And third, remedies. The loan spells out what the lender gets to do when a borrower defaults. And in this case, that included asking a court to install a receiver. A receiver, or an appointed receiver, is an officer, a fiduciary, a representative of the court who is selected to take charge of, hold, and manage specific funds, assets, or property involved in litigation. The primary purpose of a receiver is to preserve the property or assets for the benefit of the person or entity in whose favor the judgment may ultimately be rendered. The receiver must obey the court's direction in all things and are not considered an agent or representative of any party to the litigation. So if you get loans, bring on investors, or have just high stake business, this step can be included in any litigation that may come your way. And finally, lesson number 3, when a company collapses, liability visits every seat at the table, and paperwork will determine how deep that visit penetrates. The former CFO is now facing civil fraud claims because if an officer intentionally deceives a lender, the law can turn that from just being a money problem into a criminal one. The founders as well, the Weavers, face potential claims from the receiver, and they may be personally liable because they are considered personal defendants in this lender's lawsuit. Because signing personally as a guarantor on a loan or any agreement means that the debt, the issues, follows you home. And lastly, that a side LLC, in this case, the side LLC that bought a vacation home with alleged loan money, it can be reached too. And if you have a side LLC doing something, receiving money, it can be reached too. Because moving money into a separate entity does not put it out of reach. The law can follow a transfer and pull it back. There are actions that pierces a corporate veil, and alleged fraud is one of those actions. Titles do not shield people. LLCs do not shield illegal transfers, and everyone who touches the money answers for their piece of it. If you are a founder signing loan papers trusting numbers that you have never checked, or moving money between businesses without clean records, this case is your preview. The whiskey is not the story. The paperwork is. If you built a business but not a legal system, you can book a legal consultation and we can talk about it and go over wherever your standing is. Because building a brand is not the same as controlling it. Ownership is what the documents say when everything goes wrong. This is why I'm the ownership attorney.